So thank you everybody for joining us for this month's webinar. This is definitely one of the most popular topics that I have done thus far. And I know from a lot of the calls that I get from folks that there's a lot of issues that we deal with that are complicated when we're dealing with paid family leave and FMLA. So, this webinar, we're going to cover New York State paid family leave. For those of you who have operations employees outside of New York State and in other states that have other paid family leave regulations, something you'll need to consider is to how those separate state laws interact with your FMLA obligations. So if you've got questions about that, you can always feel free to reach out. Everybody is muted, but if you've got questions, feel free to unmute yourself and you can ask them, or as always, you can put them in the chat. And happy to answer them as we go along. If there's things that come up that are specific to your organization or things that we talk about today that raise questions for you that are specific to your organization and you don't want to ask them on the call with everybody today, feel free to reach out to me after the fact, and happy to take those questions as well. So I'm going to screen share and let's get started. Okay, so New York State PFL, FMLA, the good, the bad, the ugly. So what are we going to talk about today? We are going to go through just a basic overview of basics of PFL and FMLA. We'll do kind of a comparison of those two statutes. What do they have in common? What are the differences? And then we're going to talk a bit about leave administration, what the process is for each of those, because they're very different, and what are some of the pitfalls that you may find yourself falling into with respect to administration of both of those. Then we're going to talk a little bit about violations and penalties, because that's actually one of the common things that people ask about when they find out that maybe they've run afoul of some of the PFL or the FMLA requirements or regulations. So we'll talk a little bit about the violations and penalties, and then we'll end on kind of some common PFL, FMLA issues that I see that most of my HR folks deal with. And then, like I said, if there's other things that come up, questions that people have, I'm sure if you have them, somebody else on the call also has them. So please don't hesitate to ask those. Okay, so New York State paid family leave, as I'm sure you're all aware, state law that was instituted back in 2016, believe it or not. And at that time, had a later effective date with a ramp up period. So we started out at 8 weeks of leave up into where we are now, which is 12 weeks of leave. The contribution amounts also had ramp ups, so those change on an annual basis. At the present time, we're at 0.373% of an employee's covered payroll. That is the rate of their contribution. It's actually down from what that percentage was last year. And it's capped at the annualized New York State average weekly wage, which annualized is a salary of $89,343.80. It provides up to 12 weeks of paid leave to individuals who are caring for a covered family member with a serious health condition, or for the birth, adoption, or foster placement of a child, or to assist loved ones when a spouse, domestic partner, child, or parent is deployed abroad on active military service. And we'll talk a little bit about the serious health condition definition when we talk about kind of the leave administration, because there are some differences as well as some differences in terms of not only those definitions between the two statutes, but also obviously your obligations and what the certifications may look like. Also, New York State paid family leave, as most of you are probably aware, currently still provides for COVID leave coverage for an individual's or the quarantine of a covered minor child. Hopefully, fingers crossed, we will be done with that in the near future when we get rid of the paid COVID leave. We're hoping that it'll be addressed by the legislature this month. Governor Hochul recently came out, which is new. She had not said anything about it previously, but she came out a week or 10 days ago and said that, the state was in fact looking at eliminating that COVID sick pay portion of the regulations, since New York is the only state left in the country that still has COVID sick leave. And so, how that will impact this provision as part of paid family leave, we'll see, but hopefully we'll address that as well. On the FMLA side, this has been around a lot longer, enacted in 1993 by then President Clinton. It's the federal law that provides unpaid job protected leave for employees for certain qualified medical and family reasons. The maximum period of leave for FMLA is also 12 weeks, and 12 weeks in any 12-month rolling calendar period. What's good about FMLA and the fact that it's been around so long is we have a really strong established base of case law now that addresses FMLA issues. So even as new things kind of arise, we've seen a lot that have come up in the mental health space and how that impacts FMLA. We've got a really good base of case law now to be able to draw from, to be able to look at and, really kind of figure out where our obligations are. We don't have that yet on the PFL side because it's so much newer. But that's always something that is helpful as we move along. So when we look at really comparison of the two statutes, FMLA, New York PFL, obviously different employer sizes. So if you don't have 50 or more employees, you're not going to be worried about FMLA, at least from a statutory perspective. New York PFL, you've got one or more employee in New York, you're going to be subject to PFL. When I say on the FMLA side, without 50 or more employees, you're not statutorily obligated. That is true. What I would caution folks about, particularly if you utilize, kind of standardized handbooks that you get from a payroll company or, whatever the case might be, make sure that you're really taking a look at those. I've seen with a lot of clients where, either the question wasn't asked on the front end or it was, and there was kind of some uncertainty there. So there's an FMLA policy included for an employer who's got less than 50 or more employees. And if it's in your policy and, it's essentially a voluntary obligation that you're taking on, you need to know that. And we'll talk, about what that is. Not that you couldn't, as an employer, choose to voluntarily provide the unpaid leave, but if you do, and you're doing it under the context of the FMLA guidelines, there's additional complications that we'll talk about in terms of how you're administering FMLA and PFL that you really might not want to take on. And so what I tell clients in that circumstance is, you can have a voluntary unpaid leave policy that mimics the FMLA regulations, but doesn't keep you bound by those specific actual legal regulations. And so that's just a matter of tweaking the language in your policy, in your handbook, making sure that it's clear that while this is a policy similar to FMLA, it's not an actual FMLA policy. And so I just caution those of you who have less than 50 employees, make sure you take a look at your handbook and see whether or not you've got that in there. When it comes to work requirements, FMLA employees got to be with you at least 12 months, have worked 1,250 hours in the 12 months from the date of the leave on a rolling back period. And they have to be within 75 miles of a site with 50 or more employees. For PFL, be with you 6 consecutive months, or if they're a part-time employee, 175 days. One of the things that always comes up as a question is whether or not that period rolls over. So for instance, if you've got somebody who is on PFL who leaves your employment, goes to a new employer, they do not get to continue the PFL that they were on. That work requirement obligation starts all over with their new employer. And so that's something to think about too. I've actually got a client right now with a situation where they know that they're going to be eliminating this person's position, but the person is on PFL and they don't want to cut them short of that. And so we're kind of working out a way for them to be able to continue to utilize that PFL up until the termination date, even though they won't necessarily be working during that period. So something to think about. Primary, I think, biggest difference between FMLA and PFL is under the FMLA, the employee's own serious health condition is a covered trigger event, whereas under PFL, with some exceptions on the maternity side, your own serious health condition is not covered. And so it would not be a triggering event for purposes of paid family leave. Interestingly, too, grandchildren, grandparents, domestic partners covered under PFL, not covered under FMLA as those immediate family members with a serious health condition. Another big thing that we'll talk about when it comes to the administration piece is intermittent leave. So I personally think, and I'm sure probably most of the folks on this call who had to deal with it would agree, intermittent leave is probably the hardest piece of any of these paid family leave or unpaid family leave obligations. Because if you've got somebody, who's got up to 12 weeks of leave and they're out, 2 hours a day or 1 hour a week or whatever the case may be, it's a lot harder to manage those situations. And so under FMLA, they can take intermittent leave in minimums of 1 hour increments, whereas under PFL, that has to be taken in full day increments. For purposes of job protection, again, FMLA unpaid, PFL paid, but both of them are protected leaves. So in the event that somebody goes out on PFL or out on FMLA, they do have job protection. They are entitled to job restoration, which means essentially same position or similar position with, same key terms and conditions. But I would put a little asterisk next to that. That isn't absolute, right? So although the intention obviously is to make sure that somebody isn't treated poorly or retaliated against because they took a protected leave, there are going to be times and situations in which a decision is made to terminate an employee who has either been out on leave or is currently out on leave. And there are situations in which that's okay. It may be a situation where you're doing an organizational restructure, and as part of that, there's a determination made that perhaps certain positions are going to be eliminated, and this person's position might be impacted. There might be situations where someone goes out on leave, and at that time, you determine that we now have uncovered bad acts by that person, or performance issues that you were unaware of until they were out and somebody else was covering their role. So there are going to be times in which you're in a position where you're going to want to term that person. And what I would tell you there is that is definitely a situation where you want to talk with counsel, because a lot of times clients will call me and say, well, I thought that I couldn't term this person, so I'm just going to wait for them to come back. And more often than not, that's probably not the right choice. If there's something that's occurred, if there's a trigger event that's come up while the person's out, more often than not, the likelihood is going to be that you're going to be better off from a risk mitigation standpoint to term that person while they're on the leave, as opposed to waiting for them to extend the leave, come back, and then take that action. So that's something that you want to make sure you've talked with somebody about. Key employee coverage. So under FMLA, as some of you may be aware, there is a key employee provision, which if at the time that the person goes out on the leave, they are designated as a key employee, and there is a specific definition under the FMLA as to what constitutes a key employee. It has to do with not only their title and their duties, but also their range of compensation and where they fall compensation-wise within the organization. So if you designate them as a key employee at that time, they have less job restoration rights and job protection, and can actually be terminated for a multitude more of reasons while they're out on leave, as opposed to somebody who's not designated as a key employee. And, I think that makes sense. If you've got somebody who's, your CEO of your company and they're out, it's much harder to operate for a 12-week period while somebody might be out in that circumstance. And so, the federal law basically is a recognition of that, to say, we understand that you might not be able to operate without this key employee for 12 weeks and you might have to replace them or whatever. There is no similar provision under the New York State PFL. So there is no way to designate somebody as a key employee or to say, that they're not entitled to that job protection as a result of their position. Injured military service member, next of kin provision. This basically allows a spouse, child, parent, next of kin of a covered service member up to 26 weeks of leave to care for them. No next of kin inclusion on the PFL side. When you've got spouses working for the same employer, they can have a combined 12 weeks for child or parent care leave, 26 weeks for military caregiver leave under FMLA. Under PFL, the leave has to be taken at different times if it's for the same care recipient. So they can't both take, a husband and a wife can't both take off the same 12 weeks in order to have bonding leave with a child if they're both working for the same employer, unless the employer allows that. But typically that's not going to be the case. And then use of paid time off. We'll again talk a little bit about this when we get to the leave administration piece. As the regulations read, under the FMLA, an employer can require an employee to use their PTO as paid leave in concurrence with the FMLA leave time, since it's unpaid. Under the regs, under PFL, an employer can't require an employee to use PTO, although the employee has the option. We're going to talk about a loophole of that when there is PFL and FMLA coverage. And so we'll talk about that. The other thing I would say, again, when it comes to intermittent leave, where it's with respect to bonding or childcare leave, if somebody is covered under PFL, then they are automatically allowed to take intermittent leave for bonding or childcare. Under FMLA, that's only allowed if the employer agrees to that intermittent leave for that purpose. It's not likely that you're going to have a situation where somebody's out for bonding or childcare leave that's going to qualify for FMLA but not PFL. So in most cases, it's going to be up to the employee to choose whether or not they want to take that leave intermittently. But just be aware of it. I suppose there could be a situation where that could come up. The other thing I would mention about the incremental leave on the PFL side is that up until a couple of years ago, there was a cap on that. As part of the original regulations, the legislature had put a 60-hour cap on that. It's not 60 hours, 60 days, 60-day cap on that for incremental leave based on essentially a 5-day work week. And so people who are working 6 and 7 days were saying, well, that's not really fair because we're capped at the same amount, even though we're working more. And so at the end of 2021, the regulations were amended so that cap was removed. And so if somebody is work 6 days a week or 7 days a week, they now are entitled to up to 72 or 84 days when it comes to that leave. Okay, so now we talk about the leave administration pieces, right? Most of us, all the stuff I've gone through now, we're probably all aware of. It all seems pretty straightforward. until you go to actually administer the leave and then find out it's not really as simple as we might often think. So the first thing I say is pay attention to the procedural differences between New York paid family leave and FMLA, right? So the most significant of that is employers solely determine whether or not somebody qualifies to take FMLA leave, right? There is no regulatory agency or department that's overseeing it to say, yes, this person qualifies for leave, or no, they don't. Unless, there's a complaint, and we'll talk about that later. But typically that's just up to you as the employer to make that determination whether or not somebody qualifies to take the leave. On the PFL side, obviously, that compensation is an insurance benefit. So it's the insurance carrier who is making that decision whether or not the employee qualifies for leave. And so one of the areas where I think employers struggle the most, and I get a lot of calls about, is wanting to understand or know, is this person, what's this person's medical condition? Why are they out for leave, et cetera? Which, again, if you've got somebody who's out on FMLA, you can have them go through the certification process. You can require the medical certification from the doctor. It's going to come to you as the employer. You're going to review it. You're going to make the determination whether or not, it's a qualifying event. With PFL, you're not going to make any of those determinations. You're not going to have access to that information. That's just going to be, you'll fill out your part of the form, which we'll talk about in a little bit. But then all of that information, the medical certification pieces, if required, are going to go directly to the carrier to make that decision. And that decision ultimately falls on them. So under the FMLA, if you've got an employee who's unsatisfied with the result, and you perhaps say as the employer, no, you know what, we've decided that we don't think that this qualifies as FMLA covered leave, their recourse is to sue you as their employer because you've made the decision. Under PFL, there is an arbitration process that is built into the regulations that really is between the employee and the insurance carrier. Because again, that insurance carrier is the one who's responsible for ultimately making the decision. So where does it come up often when you're dealing with the FMLA issue in particular, is deciding whether or not somebody qualifies for leave for a serious health condition. And the definition is essentially the same under PFL and FMLA. So it's an illness, injury, impairment, or physical or mental condition that involves inpatient care in a hospital, hospice, or residential care facility, or continuing treatment or supervision by a healthcare provider. And so that certification piece is where you as the employer from an FMLA perspective are going to be making that determination, are going to be getting that information to decide whether or not somebody qualifies for that serious health condition definition. The FMLA regs give a little bit more specificity. So when they're talking about inpatient care, they're talking about any period of incapacity or subsequent treatment in connection with an overnight stay. So if somebody goes to the emergency room, they get admitted to the hospital overnight, they're released the next day, but the doctor says, you've got to follow up with me in a week, or, you've got to stay home for a week and then follow up with me. That entire period could qualify and would qualify in most cases for FMLA leave because they had the inpatient stay and now they've got subsequent treatment or a period of incapacity in connection with that overnight stay. The other piece of the definition is if there is a course of continuing treatment. So if there are examinations that are being done to determine whether or not somebody has a serious health condition, and there's multiple evaluations that need to be done in order to make that determination, that's also going to constitute a basis for FMLA leave. What I would note about that is it's so broad from a definition standpoint. It also includes telemed visits. So if somebody sees a doctor and then has a follow-up telemed visit, that's going to be enough to trigger that definition of a continuing course of treatment. And if they're in a situation where it's a period of incapacity followed by some sort of treatment, that period of incapacity has to be more than 3 full consecutive days with some additional follow-up treatment. And as part of that, they also have to have been treated by a healthcare provider within the first 7 days of the incapacity. And they have to have been prescribed a course of treatment or have had at least one other visit with a healthcare practitioner during the first 30 days of that incapacity. So again, while I say, we're going to look at the certifications and be able to make a determination, it's sometimes more complicated than that, right? We have to go through each of those steps to determine, do we have enough information in order to be able to make that assessment? Do we think that this person meets the definition and is going to qualify? Those definitions also exclude requirements for pregnancy or chronic conditions, which aren't necessarily going to require continuous treatment over a period of incapacity. There may be incapacity alone during periods of either pregnancy or chronic condition that would qualify for FMLA, wouldn't require, the additional visits or the 3 days, for instance, of incapacity. It might just be 1 day here or there. So if you are looking at somebody's certification on an FMLA side and trying to make a determination of whether or not they've got a serious health condition, my advice is more often than not, you're going to err on the side of being inclusive and more than likely going to determine that that person does meet that definition, simply because it's pretty hard not to when you look at how broadly the definitions are written. But I will tell you, I have had cases where people have made requests for FMLA leave for things that do not trigger that definition. And so, as an employer, you've got to weigh and balance what that looks like, because sometimes an employer will say, well, you know what, I don't really care that much. It's unpaid leave. And so if the person, is ill and wants to take the unpaid leave off, fine. But you've got to be careful. You're also not setting a precedent for allowing people to take FMLA leave in situations where it's really not an FMLA leave qualifying event. Or, again, we'll talk a little bit about how that works when you've got a situation potentially where you as the employer may decide that somebody qualifies for FMLA leave, and then they are simultaneously applying for PFL and the carrier denies a PFL leave. And, kind of how you deal with that situation. So what are some of the biggest mistakes that I see when it comes to leave administration? So the first, I entitle, and I'm sure for those of you who have had more than one conversation with me at any point over the time I've been doing this, you've heard me say, no good deed goes unpunished. And that is true when it comes to FMLA and PFL leave. So often I will find that clients will call me and be talking to me about somebody who's out on leave. And, this person's been out for quite a while and we're trying to figure out what we're going to do with them. And, they're not ready to come back, or they're not talking to us anymore, or, there's some complication now about when this person returns. And we'll go through kind of that conversation about, like, when did the FMLA start, or, whatever, when did they begin the leave? And they'll often find out that employers will have allowed the employee to take time off for a medically related condition that would otherwise qualify for FMLA or PFL without actually requiring the employee to timely take that leave. So under the regulations, it's the employer's obligation to direct FMLA leave time. And so if you don't tell the employee this is going to be a qualified leave, here's the notice paperwork, here's the certification paperwork. If you don't do that and you just let that person start taking the time, and in your mind you're saying, well, they got 12 weeks, I'm just going to, kind of track that. you have never started that 12-week clock running, because it's your obligation as the employer to go through that documentation process and direct that leave. The same's true on the PFL side, although we see it less because here more employees want it because it's paid. But same thing, if you allow somebody to take time off that would otherwise qualify for PFL, and you haven't actually had them go through the process of applying and going through that, you can't then on the back end say, well, we're going to offset that, or we paid you during that period of time, and so you can't take as much PFL time. Because it's your obligation, the employee isn't the one who's going to get the short end of the stick there. It's going to be you as the employer. Now, if an employee is on FMLA leave that also qualifies for PFL, and for whatever reason they don't file for PFL, the regulations say that you can still count that time toward their PFL leave if you have formally gone through the process of documenting and directing it as FMLA leave. Okay, so again, something to think about, not likely to occur because, again, I can't imagine a scenario where somebody wouldn't want to file for paid leave. But sometimes it comes up, or it may be something that, they just, again, didn't get around to for whatever reason. They don't get the extra benefit of that additional time. The second piece, I think that's a big mistake when it comes to leave administration, is not knowing your policy on concurrent use and the PTO requirements. So as I mentioned, when we looked at that chart that compares the regulations, FMLA allows an employer to require that PTO time be used in conjunction with FMLA time, and PFL does not, right? So your FMLA policy, and certainly if I drafted it or reviewed it, likely says, if you've got available PTO time, we're going to require you to use that in conjunction with and in concurrence with your FMLA leave time. So you don't get more than 12 weeks, but whatever portion. If you've got 2 weeks of PTO, the first 2 weeks of your FMLA will be paid because you will be using that PTO time. So again, PFL doesn't allow you to do that. It's at the employee's option, except when PFL leave also qualifies for FMLA leave, you can require the use of PTO because you're essentially requiring it in accordance with your FMLA policy. And so it's okay to say your PFL and your FMLA are running concurrent, and we require you to use your PTO in accordance with our FMLA policy. So again, first 2 weeks of your leave is going to be paid PTO. And then the remainder of it, you could use as paid PFL leave. If you are going to pay somebody during the period of PFL, whether it is that you're paying the full shot, maybe somebody, instead of the 67% that they're entitled to, you have a policy that says that you're going to pay the difference between that 67% and the 100% of somebody's leave. When they get their pay from PFL, you as the employer are also entitled to receive that pay back if you are covering that additional portion and there's some sort of a paid leave policy. It often comes up a lot with, for instance, maternity leaves, paternity leaves, those sorts of things where we just say we don't want to make the person have to go through the whole rigmarole and worry about any gap periods. We're just paying 100%. You're entitled to that portion back that would otherwise not be PFL pay. As I mentioned too, on the intermittent leave, another mistake that sometimes comes up is because FMLA allows the 1 hour increments, PFL requires that somebody take it in full day. You've got a couple of options about how you handle that. So you can allow the FMLA leave in the 1 hour increments and say, that time will add up to however many PFL days. Once you have 8 hours of incremental use, you've got 1 PFL day that it qualifies for. Or if it qualifies for both PFL and FMLA, you can require the use of full day intermittent leave during the PFL period. The FMLA regs allow for that. So again, it's kind of a choice that you as the employer can make. But what I would say is whatever choice you're going to make there, it should be consistent, right? You should be willing to live with that choice for all of your employees, not that we're going to make one, option available to this employee. And then when somebody else's issue comes up, it's going to be a different scenario. So I thought that this is kind of helpful to see just from a flowchart perspective in terms of what are your responsibilities, what's your employee's responsibility when it comes to FMLA. So first step is the employee is going to notify you when they know that they have a need for leave. Now, what I would say is there are no magic words. As I said before, there's a ton of case law on the FMLA side. And so we know that somebody who is requesting FMLA leave, like with a reasonable accommodation request, they don't necessarily have to say the words, right? So if somebody comes to you and talks to you about, a medical condition that they have when they think they're going to need time, or they've got a family member who's ill and they're talking to you about the need for taking time, you as the employer have an obligation to recognize, hey, this may be an FMLA qualifying event. And so we need to start having that discussion, even if the employee doesn't use those words, right? They may not know or be aware or understand the difference in the regulations. So if they notify you that there's a need for leave, then you as the employer have to make that initial determination to notify the employee whether or not they're eligible for FMLA leave within 5 business days, okay? If they're not eligible, we stop there. Leave's not FMLA protected. They could, request it again in the future. Maybe they haven't worked the 1 year or the 1,250 hours. Maybe they're not, within a 75-mile radius of a facility that has 50 or more employees. So if they're not eligible, that's kind of where it ends. If they are eligible, then again, you as the employer have to provide them with the forms that outline their FMLA rights and responsibilities, as well as any request for certification. So if you're going to have them complete a request for medical certification, either for themselves or for caring for somebody else with a serious health condition, you're going to need that information. You're going to tell them you're going to request those certifications. If you request the certification, then the next step obviously is the employee has to provide you with that completed certification. If no certification is requested, or it is and the employee provides it, then you have to, as the employer, make that determination whether or not the leave has been designated as FMLA leave, and you've got 5 business days within which to do that. Again, if for whatever reason it's not FMLA protected, you've decided after the certification it doesn't meet the criteria, you're going to notify them of that, and kind of that's where it stops. If it has been designated as FMLA leave, then the leave is FMLA protected. And then again, we've got the job restoration and job protection criteria that comply when the person comes back to work. Sometimes we run into a scenario where we request a certification and either the employee doesn't comply, they give us a lot of reasons why they can't get a hold of their doctor. And so I would say when you're handling those in the leave, you need to document, right? Document your follow-up requests, because at some point, if the employee isn't compliant, you as the employer can say you haven't met the requirements for your participation in the FMLA interactive process. And so we're denying you the leave because you didn't cooperate. But if that's the case, we want to make sure that we can show we sent them an email, we made a phone call, we left a voicemail, here were the requests, we sent them a letter, and the person just didn't comply, okay? Because again, we don't, as the employer, don't want to have liability because an employee didn't follow the requirements that they were supposed to follow. On the PFL side, obviously a little bit different, right? So they're going to complete the PFL 1 form, part A of that. They're going to then provide you as the employer with PFL 1 form, and you're going to complete part B, and you have to return it to that employee within 3 days. And then it becomes the employee's obligation, depending on the basis for which they're requesting the leave, to complete any additional forms that are required, and then to send those forms and whatever supporting documentation is necessary to the insurance carrier. And then the insurance carrier has an obligation to either accept or deny that PFL claim within 18 days. Now, one of the things we'll talk a little bit about when we talk about common issues, you'll see on here it says, you do not need to wait for this decision to start your leave. I understand why that's the case and why the state thinks that that's a good idea. But from an employer perspective, it does create some issues that we'll talk about. When it comes to the specific forms, I'm happy to send these the Power slide deck out after the fact if you want the links. But I've given you the link to the USDOL FMLA forms. They were recently updated. So if you're using old forms, make sure that you've updated them to the correct forms now. But there are both notice forms as well as certification forms that are required, as well as obviously your postings. And then on the PFL side, I again gave you the link to where you can find that PFL1 form, but I've outlined here, these are the questions and the information that you as the employer are going to be responsible for providing when it comes to completing that form. Now, as you'll see here, there's nothing related to, what's the person's medical condition, what's the basis for their leave. All you're providing really is substantive information. What's your employer identification number? What's this person's classification code? What's the employee's occupation code? What were the wages that were earned by them in the last 8 weeks preceding the PFL date? Are you requesting reimbursement from the carrier? So is it a situation where, again, you're paying 100% of the person's pay and you're looking to get reimbursed for that? Is there any disability period as part of, before they're going to qualify for PFL? And then, what are the total number of weeks that the person may have already been out on disability before they're taking PFL or vice versa? And then just the basic information relative to your insurance carrier's name, address, PFL policy number, et cetera. And then you have to sign and date that form and return it to the employee within 3 business days. So let's assume we've gone through the process and on the FMLA side, we either didn't handle the certification piece correctly, or we denied somebody leave and they think that they were otherwise entitled to it. They've got a lot of options for how they can go about bringing a claim. So the U.S. Department of Labor, the Wage and Hour Division, is the agency that's responsible for administering and enforcing the FMLA for all private, state, and local government employees, as well as for some federal employees. And they're also the agency that investigates any FMLA complaints that are filed with the DOL. If as part of that investigation, the DOL can't resolve the situation amicably between the employer and the employee, then the Department of Labor could bring its own action in court to compel your compliance with the FMLA. Also, an employee can bring a private cause of action. They don't have to go through the DOL. They can bring their own cause of action against an employer for a violation of FMLA. In general, any allegation on the federal side for FMLA is going to have to be raised within 2 years from the date of the violation. So that's typically going to be the statute of limitations that you're looking at. There can be an expansion to 3 years if the allegation is that it was a willful violation. But I can tell you in the 22 years I've been doing this, I've only ever had one FMLA violation claim, civil action that was brought. So we don't see it a ton, I think partially because it's so complicated. The regs are so complicated that employees really don't understand what their rights and obligations are under FMLA. And so they're hesitant to bring claims, but it is a possibility. If somebody were to bring a claim for an FMLA violation, they're entitled potentially to lost back pay, lost front pay, liquidated damages. And those would be equal to whatever amount they were awarded in lost back or front pay. You can't recover emotional distress or punitive damages. under the FMLA, which is different than if somebody was just bringing, for instance, a wage and hour claim, or a harassment or discrimination claim, where some of those emotional distress or punitive damages are available. Not available under FMLA, but they are entitled to their attorney's fees and costs, which can be in a lot of cases more than the underlying claims for damages. They're also potentially entitled to injunctive relief. So whether it's brought by the DOL or brought by an employee as part of a private cause of action, you can have an order by the court that tells you as the employer, you have to take some particular action, like, reinstating somebody to a job or granting the person the leave, or that you are prohibited from taking some sort of action against an employee. On the PFL side, there are penalties primarily for coverage non-compliance, because again, you as the employer aren't the one responsible for making the decision whether or not somebody is entitled to the leave like you would under FMLA. So those causes of action likely aren't going to apply. But if you don't have the coverage in place that you're supposed to have, the board can impose a penalty not in excess of 0.5% of your entire payroll during the period of non-compliance, plus an additional sum not in excess of $500 for each period of non-compliance. It's also the failure to secure the coverage is also a criminal misdemeanor punishable by a fine or imprisonment of up to 1 year, or both a fine and imprisonment. And then if you have subsequent violations, those numbers obviously increase. And then in addition to the penalties that are assessed under Section 2, the employer can also be liable for either the total value of any disability or PFL benefit claims that were paid out by the special fund for benefits during the period of noncompliance. So it's like workers' comp. If you as the employer don't have the coverage in place that you were supposed to have, and somebody has a claim and it has to get paid out, the state pays it out of its special fund, but then will come back at you for repayment of the benefits that were paid out when you should have had the coverage in place, as well as civil penalties. When there can be a violation for discrimination or retaliation. So primarily when you've got, as I said, with PFL, because it's not you making the choice as to whether or not the person has the coverage, if there's a claim that they should have gotten leave and they didn't, that's an arbitration process between them and the carrier, and they can, fight that out, and the carrier and has to deal with that in the arbitration. But if you don't allow someone to apply for PFL, or somebody went out on PFL leave, came back, and they were fired, or you didn't reinstate them to the same position that they were entitled to from the job protection standpoint, then they have rights with respect to you as the employer. So the first step in the process is that the employee has to request that you as the employer reinstate them to their same job or a comparable one. And so the state has said for the employee to request reinstatement, there's an actual form that they can complete. They give that to you as the employer. They also send a copy of that to the state, so that the state is aware of the fact that somebody has been denied reinstatement and that they potentially have made a request and that there may be a claim that is related to that. And then as the employer, you have 30 calendar days to respond to that request. If you reinstate the employee, there's no further action that's necessary. If the employee is not reinstated, or the employee is not satisfied with the response that they receive from you as the employer, or if you as the employer, for whatever reason, don't respond to that request within the 30-day time period, then the employee has the right to request a hearing with the Workers' Compensation Board. And so that moves you on to step 2, which is they can complete the form for paid family leave discrimination or retaliation. They fill it out, they attach any required documentation, information supporting documents that they may have, and then the board will take all that information, put it into a case file, And they'll schedule a hearing to occur within 45 calendar days of the date that that complaint was filed. And if that's the case, then you as the employer and the employee have to appear at a hearing with a workers' compensation law judge who will go through the complaint, will go through your response and determine whether or not they think that there has been some violation of paid family leave, whether there was some retaliation that occurred, whether there was a failure to engage in the required job protection. And then if they find that there was some violation, then you as the employer can be ordered, not only to have to reinstate the employee, but again, to pay back wages, attorney's fees, penalties, similar to what you would under an FMLA violation case. And as I said, in order to file a discrimination complaint, the employee does first have to have gone through the process of requesting reinstatement that you've denied, or that you didn't respond to, and they have to ensure that they've submitted all of their documentation to the state. One of the other pieces that I think is important to note is there is a separate New York State labor law retaliation provision that was enacted just last year by Governor Hochul that relates to things that come about under the labor law. And so if there is a labor law investigation and the commissioner finds that an employer has violated the section of the labor law that applies to retaliation, and they've taken some action against an employee either for filing a claim or making a complaint, whether it be a wage and hour or potentially a PFL claim, then there can also be civil penalties that are assessed under that specific separate cause of action for that complaint. And so civil penalties not less than 1,000, no more than 10,000. Again, if this is not your first offense in the last 6 years, that number max jumps from 10 to 20. But then the commissioner also has the similar ability to award appropriate relief, including enjoining the conduct of the employer, ordering liquidated damages, ordering lost compensation, and the employer or their officers, agents of a corporation, partnership, or limited liability. So it could be, your shareholders, it could be the members, it could be whoever was the person who made the decision, whether that was you or somebody else, as to whether or not this person should be or should not be reinstated, or whether, there was going to be retaliation that occurred. Could also have personal liability under this provision, and that's a Class B misdemeanor. So again, something we want to be really, really careful about when it comes to figuring out whether or not we're going to be reinstating somebody after a leave or not. Okay, in the last couple minutes, just want to talk about a couple of common PFL FMLA issues. The first is interaction with other leaves. So for instance, we sometimes run into situations where somebody is qualifying for short-term disability as well as PFL. So oftentimes comes up in a situation where somebody may have been, for instance, given birth. And so, depending on whether or not it was a natural delivery or a C-section, your first 6 to 8 weeks of leave may qualify for short-term disability. And then, but at the same time, it could also qualify for PFL. So while those two benefits can't be taken at the same time, employees are able to choose how they can best use both of those benefits to support their needs. So again, for example, somebody who qualifies for short-term can either choose to immediately take all or any portion of their available short-term disability and then take PFL leave at any time within that first 12 months. Or they could say, you know what, I'm going to take PFL immediately and I'm not going to take any short-term disability. Most often that comes to a determination on what the compensation is. And because the disability payment is still so low in New York at $170, a lot of people choose to take the PFL leave immediately, or in a situation where you may have a policy where you as the employer are going to supplement or provide a period of fully paid leave. You can have a policy that, again, the person has the option of what they want to do, but if they take disability or whatever first, you could make it so that they're not eligible for that paid leave if you want to shorten the amount of time that somebody could potentially be out. There might also be times when an employee needs to use both short-term disability and paid family leave in the same year, but for different qualifying events. So in those cases, just be aware that employees can't take more than 26 weeks of combined disability and PFL in a 52-week period. If they plan to use both short-term disability and PFL, they have to complete a separate request for each of those. Again, because they're separate benefits that can't be taken at the same time, they require you to have separate documentation, both from the employee and the employer side. Unapproved leave. So this is the one I was talking about before, where you saw I noted on the PFL 1 form, it specifically says you do not need to wait for our decision to start your leave. But we've got a scenario, again, where employers are prohibited from discriminating or retaliating against somebody for requesting or taking paid family leave. And so, under that, under the regs, an employee has to submit their completed request for PFL within 30 days of the start of their leave to avoid losing benefits. And the regulations state that until an employee's PFL is approved by the carrier, the employee is not considered to be on paid family leave. And so it's up to the employer to determine how to treat the time off. But then again, like I said, we have this PFL form that specifically says you don't have to wait for our decision to start your leave. So now it puts the employer in a tough spot, because what if the person puts in the PFL request to the carrier, takes 2 weeks of leave, carrier then comes back and says, your claim's denied, your time off wasn't eligible for PFL. Well, now this person essentially has taken 2 weeks of unapproved leave. And, the regulations say it's up to you as the employer to determine how to treat that time off. Well, if any other employee took 2 weeks of unapproved leave, right, there would be consequences for that. So it really complicates that scenario for you as an employer, because then the question is, what are we going to do? How are we going to treat that time off that employee took? And do we think, I've got a scenario right now with a client where the employee requested PFL, really, from what we can gather, in a defense mechanism for some poor performance management information that they had received. And then in that 30, started leave immediately, and we're, 25, 26 days into that 30-day period, and they still haven't requested the leave. And so it really then creates a problem for you as the employer in terms of, is this going to be a retaliation claim? Because the retaliation regulation says I can't discriminate or retaliate against, not just for taking the leave, but also for requesting the leave. So what I say is, generally as an employer, you're going to want to err on the side of caution. You're going to allow the employee to take the leave prior to getting the carrier's decision. If their leave is ultimately denied, then as the employer, you can figure out how you're going to address that after the fact, whether that be, again, a decision that we're taking some disciplinary action, or whether we're just going to say, that was 2 weeks of unpaid leave, or, whatever that time frame is that the person was out. So something to think about. I would tell you, if you end up in that situation, particularly if you're there with an employee who you've got other concerns about in terms of behavior, performance, et cetera, that's a conversation that you want to have with counsel. It's not a decision you want to make in a vacuum, because you don't want to end up, accidentally creating liability for yourself that you could have otherwise avoided. Okay, questions? Didn't see anything in the chat. Hopefully this information was helpful. Oh, we do have one. If an employee is applying for PFL to care for a parent, do they need to use 8 hours, or do they have an option of 4 hours? It's gonna be based on whatever their regular workday is. So if they're gonna take it intermittently, it's going to be in 8-hour full day increments. If your policy allows them to take it in less than 8-hour increments, then you're going to be bound by whatever your policy is. Okay. If there's no other questions, thanks everybody for participating. Great to see you all here. Hope to see you on our May webinar. I'll be sending that information out in a couple of weeks. And if there's any questions that come up after the fact, like I said, please feel free to reach out. I'm happy to answer those on an individual basis. Hope everyone has a great rest of your day. Thanks.